Hello and welcome to week 2 of Legal Research. This week we gotten over the preliminaries. Hopefully you're all know where we're going and how we're going to go about going there. And we're moving on to the substantive material, and we're going to start looking at what legal research actually means. And the reading for this week and for last week for that matter asks some of the tricky questions about what legal research actually is. It's something that we kind of presume is something that's simple and straightforward, and we know when we see it, but it's something that is many lawyers have taken for granted, that legal research is a particular thing and is done in a particular way. We call it doctrinal legal research. But when we start moving into other disciplines and we look at the way in which disciplines pay a great deal of attention to the way in which they do research and they validate knowledge, we find that law starts looking a little bit flimsy. Science in particular takes great pains to try and verify what they're saying is true, that the information is accurate. And law seems quite often content just to go, oh, it's in a piece of legislation, so therefore it must be true, or a judge said it, therefore it must be true. So we're moving beyond. We looked at in the notes at the sort of the different scales of research, and there's that very basic. It's not that basic, I know, but there's a top-level research question of law: is what is the law? You know, what is the answer? What does the law say about this particular question? But when we start moving through those levels of complexity of, well, why does it do that? How does it do that? Is it effective at doing that? Can we validate the truth statements that are implicit in that? Remember, we've got all kinds of things in laws in the past that say things like Indigenous people aren't human beings, people of a particular religion aren't human beings. We've also got laws that say corporations are human beings, which is patently not true. So we've got all kinds of ridiculous stuff in law, and I think there are things that would not stand up to the kind of rigour that would come from other disciplines. So it's a very serious issue. And certainly that surface level, and when you're in first year, I think we let you focus on that surface level. Just find what the law is, find what the law has to say. That'll be enough, that's fine. But, you know, each year we're ratcheting up the difficulty, it's becoming more complex. And this year we're starting to ask those bigger questions. And it's the kind of thing that we'll find that your IRAC strategies don't really help us with. And when you start working across disciplines, and when we look at the context that we're looking at this term, the recidivist drink drivers, you know, there is a point at which just saying, oh, well, someone thought it was a good idea to put it in a law is not good enough. We need to look at data, we need to look at statistics, we need to look at medical discourse around addiction, we need to look at in juridical discourse around punishment and whether people are deterred or rehabilitated by different strategies. So I know that for some people love first year, okay, because it's nice and simple, and we lay it out and we go, here's the rule, that's how you apply it, answer the question, there's a tick. And some people then struggle when we move to second year, when suddenly it's like, well, actually that's the training wheels, the world's a lot more complicated than that. But I hope you'll share a bit of my enthusiasm for law here, in that this is where it gets interesting. This is where the individual attitude, belief, understanding, form of argument starts to come into its own. Because let's face it, if law was as simple as just looking up what the law book said, we would have robots doing it. We'd have artificial intelligences doing it all the time. We wouldn't need clever people to do it. And we do need clever people in law because it's far more complicated than that. So this week we're starting down that journey of unpacking and looking at how do we understand what legal research is, and then how, of course, do we apply it. The first of the navigating sections this week talks about government and law reform papers, and I guess this was where we start as the most easy, accessible form of knowledge around law, and probably the form of knowledge that people are likely to access first, ordinary people. They're more likely to access a government website, for instance, than they are the Commonwealth law reports. So we're starting with that as our first of our materials and resources to look at, and we're also starting to think about how the different types of law work with each other. And I'm doing another video shortly on the bedtime rule, which is a bit of a a parable which will help you understand why we have legislation and case law and how those things relate to each other. In the equilibrium section this week, there's some tips on reading and on this getting project started, and I hope you'll find that the videos in that section are really useful. I think that they're great, and they've got lots of really interesting tips. So this week we're thinking about reading and how do you read more effectively, and then we're also looking at how do you get started on a writing of a project, because this is where you need to start writing, and this is why we're doing those weekly tasks, because we're trying to get you out of the habit of trying to write something up a week or 2 weeks before it's due, starting with simple planning stages and working through those planning stages before you actually get a project up and running. And so on to the workshop for this week, and this is all around framing a debate. Now, last week we looked at points of view, and the idea of that was really to establish that on any particular issue there are lots of different points of view, and they reflect different interests, and they'll often reflect different positions, where someone's interest will be, I want this to happen, they'll therefore hold a position that this is what I want to happen. And when you do a little bit, and you may have done some work on mediation already, you know that sometimes interests and positions can be different. Sometimes people will be really hard line about holding a particular position, but their interest is actually something quite different. And they might be holding that position for all sorts of reasons that are not necessarily the same. And part of what a mediator can do, which is also what a good researcher can do, is move beyond those positions and actually start looking at those interests. And when someone says, I'm 100% on this way, you can actually say, well, actually you're not really, this is actually what you are trying to say, but you're arguing it in this particular way for some particular reason. So there's a lot of, emotional intelligence and I guess understanding of different points of view that goes into being an effective legal researcher. Not taking things at face value, not taking at face value someone who says, I'm all for morals, I'm all for more control, because you might find they're actually really in favour of something quite different. So last week, really what we wanted to do was establish those idea of different points of view, and what we're doing in this course, I think, really is moving you out of that mindset of thinking there is a right answer to every problem. In law, we look at wicked problems, and in law reform in particular, we look at wicked problems. These are things that don't have solutions. If problems all had easy, straightforward solutions, we wouldn't have law. When you think about it, if it was easy, if in any particular dispute or problem there was an easy, okay, this is the answer, we wouldn't need lawyers. No one would go to court. If any form of social control around criminal law or bad behaviour, if we had an answer to it, we wouldn't need courts. We wouldn't need police, because we would use that particular answer to solve the problem. So we talk a little bit in the materials about wicked problems. I don't know if it's this week, maybe it's coming up. But all the important and interesting problems in law are wicked problems. They're all ones that require multiple complex sorts of solutions. So what does that mean in terms of this week's workshop exercise? This week we're looking at turning those points of view that we looked at last week into debates. Actually establishing the pros and cons, splitting the issues into separate issues, and then looking at which are each of the positions and which are the pros and cons of those positions. So it's a logical brainstorming breakdown kind of activity, but it's something we don't do very often, and I think particularly we often get taught, and schools are often really bad at this, at saying you just have to find the right answer, just give us the right answer. And you go, okay, we'll find what the right answer is. Wicked problems don't have a right answer. So it's all about establishing those different parts of that debate. Okay, this is the overall issue. There are three aspects to this debate. In aspect 1, here are the different positions. Position A, position B, position C. Within position A, what are the pros for this side? What are the pros for this? What are the cons for this? And you start building out this complex understanding of an issue that moves you beyond what is the right and wrong answer. And that will be important next week, because we'll then move on to looking at turning this into a conversation. And a research paper is at its heart a conversation. It involves a whole lot of different voices and a whole lot of different positions and perspectives, and you're weaving that conversation in a way that demonstrates an argument, because you have to have a strong argument of your own. You have to be saying, this is what I'm saying. I am telling you this, and I'm backing it up by this evidence. And part of that evidence is the conversation of what other people are having to say. So I think that you'll find that's a different way of thinking about writing than you may have done in the past. But it's absolutely important. It's absolutely crucial. And if you go on further, I mean, this will be extremely useful for you in your other law subjects, I'm sure. But it's going to be very crucial if you move on to further study, if you move on to honours, for instance. And also, it will be important if you do substantial research in your professional life. I mean, when you're actually having, and most of us will have to do this. Most of us will be presented with an untidy set of facts around a problem, and we're going to need to present that to someone along with an argument. Even if it's just an argument around how we change the filing system at work, you still need to be able to say, here are the different perspectives, here are the pros and cons, and this is what I'm arguing that you need to be able to do. So these are really important core skills. Anyway, I hope you're going to find it very interesting, illuminating and useful, and we'll talk more about this in the workshop this week.